Assalamualaikum warahmatullahi wabarakatuh. My name is Zahratul Hanan binti Sahrul Nizam. My magic number 9Y90628. So now, my group will present about the benefit of arbitration in Malaysia. The contents in our presentation are: first, we have introduction. Second, the benefits of arbitration. We have list 4 benefit of arbitration, and the third is conclusion. So I will present about the introduction and the first benefit of arbitration. I will talk about the arbitration first. As we know, arbitration is one of the alternative dispute resolution, which we call as ADR. The origin of the concept of arbitration for dispute resolution began with a statement made by Holdsworth in History of English Law. The statement by him is, "The practice of arbitration comes naturally to primitive bodies of law. Courts were established first and disputes were settled by the courts, and the practice of dispute resolution continues because the parties to a dispute want to settle them with less formality and expense than is involved in a recourse to the courts." The meaning of the statement by Holdsworth is, because of the parties want to settle down the dispute with less formality, that make the practice of dispute resolution continuous, which is an arbitration. It is clear that the continuous of dispute resolution is because the parties want the less formality process rather than use litigation. As we know, the litigation process is the formal process. Because of that, the arbitration is mean that the practice of dispute resolution continues because the parties want the less formality. As we know, arbitration in Malaysia have its own act. The act is Arbitration Act 2005. So in the Arbitration Act 2005 define the meaning of the arbitration agreement. According to Section 9, Subsection 1 of Arbitration Act 2005, define the arbitration agreement is an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. It is clear that the arbitration agreement must be in the written, whether it is contractual or not. This already has been stated in Section 9, Subsection 3 of Arbitration Act 2005. This section stated that an arbitration agreement shall be in writing. For example, they must have such as document, not just talking only, meaning that not just the discussion of the resolution only. The process of arbitration must be written. So, the parties choose arbitration as the best resolution to settle their disputes because arbitration gives more benefit to the parties than litigation. So, because of that, we will talk about the benefit of the arbitration in our presentation because many parties choose the arbitration as the platform for they resolve their dispute then rather than they use the litigation process. Here we have 4 benefits of arbitration, which are: first, private and confidential; second, fast procedure; third, cheaper cost; and the last, binding decision. The first benefit of arbitration is private and confidential. Privacy in arbitration means that the parties and the arbitrator will be excluded and have no access to the arbitration proceedings without the consent of parties, meaning that the privacy of the parties and arbitrator will execute and they not have any accesses to the proceeding that give the resolution that not have any consent between the parties. Next, the means of the confidential. The confidential is the proceedings, materials disclosed or created during proceedings, and the arbitral award cannot be disclosed by any witnesses or any individuals attending or tribunal without the permission by the consent of the parties, meaning that the arbitration always keep on confidential. The proceedings, the material that have been disclosed or created during the arbitral award cannot be exposed even though to the witnesses or the tribunal or the individuals attending without the consent of the parties. It is because the parties itself want the arbitration process always confidential, meaning that always keep confidential. So, because of that, the privacy and confidentiality in arbitration is a related concept. If the arbitration process or hearing is open to any strangers, meaning that it is impossible to maintain the confidential in the arbitration process itself. Although the arbitration was conducted private but free to disclose that transpire to others, then the privacy will be pointless, meaning that the arbitration like not have the privacy, even though the arbitration conducted private. So because the private and confidential in arbitration, most parties choose the arbitration process for the alternative dispute resolution, meaning that they choose the arbitration for their ways to resolve their dispute. It's because the parties believe that their dispute will be kept privacy, and usually the parties choose the arbitration because of they don't want any people know about their dispute and how they resolve the dispute without litigation process. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Khairunnisa binti Khairudin. My metric number is 9190625. So now I will continue some of the benefits of arbitration in Malaysia, which is fast procedure and cheaper cost. So we will start about the fast procedure first. The first point is the date for arbitration can usually be obtained a lot faster than a court date, as arbitration is less formal and more flexible in terms of scheduling. Okay, as we know, if we use court proceedings, it will take much longer as we need to go through the process, such as first reading, second reading, and so on. And let's say that both of the parties agreed to discuss and settle their dispute at a cafe or restaurant, they might proceed with it. So then, they can discuss and settle down their dispute. Let's say that they are not agree with the decision, or one of the parties are not agree with the decision. They can find a way until both of them are agreed with the decision that the arbitrator made. Okay, the next point. The parties does not have to wait as long as the court hearings, because the discovery process could be done as using a simple phone call. It says that arbitration does not need a formal procedure as the court procedure. We can solve everything in the fastest way. Okay, here's an example. For instance, let's say one of the parties is a doctor who are out of state. The cost of bringing them to trial or going out of state to take their depositions may be prohibitive for trial and will cost a lot of money. But in arbitration, you can just only use the doctor's records and reports. It is easier and can save a lot of time. Okay, the last point is the limited right to appeal arbitration awards typically eliminates an appeal process that can delay finality of the adjudication. And plus, the limited right to appeal arbitration awards typically eliminates an appeal process that can delay finality of the adjudication. The faster the dispute is settled down, it is more better, because a general timeline consists of 3 to 6 months from the filing of the arbitration to the final payment date. American Arbitration Association AAA rules state that any claim under the amount of $75,000 can be fast-tracked to be completed even faster. Under a fast-track arbitration, the arbitrator sets a hearing date within 30 days of legal claim. Okay, now we will go to the next benefit, which is cheaper cost. Okay, so the first point is the fee paid the arbitrator is a lot less than the expense of paying expert witnesses. Okay, partly that is because the fee paid the arbitrator is a lot less than the expense of paying expert witnesses to come and testify at trial, and plus, arbitration does not include expert witnesses or require as much legal preparation like the court proceedings. Okay, so in arbitration, both of the parties often split the cost of the arbitrator, meaning the process is less cheaper than it will be because the amount of the money they split to both of the parties. Okay, so the next point is lower costs in preparing for the arbitration than they are in for preparing for a trial. Partly, this is due to the fact that the procedures are often more relaxed than the trial proceedings. Once an arbitrator is chosen, they will select the date, time and location of the arbitration. We does not need to follow the procedure like the court proceeding and go to the court to settle down our dispute. We can just do it. Maybe both of the parties agree to do it at a cafe or restaurant, so it will be more relaxed and no stress. Okay, so the last point is discovery is much more limited in arbitration and appeals are very limited, so the scores are all safe. Okay, in court, the parties are required to follow procedural rules that apply to every case. So let's say that one of the party does not agree with the decision. They have time to appeal and gather the proof. But in arbitration, the discovery is limited so that it is hard for the party to make an appeal. So if we does not need to make any discussion more to settle down our dispute, it means that we does not need to use our money more. Arbitration can really saves money. Okay, I think it is all from me. Thank you for lending me your ears.
Hi, my name is Hadi bin Abd Ghani. My matrix number is 9190592. And I'm a member of Group 4 from TTL2. And now for my slide, I will explain the fourth point of the arbitration proceeding, which is the award that made by the arbitrator was a final binding decision. The first explanation is if arbitration is binding, there are very limited opportunities for either side to appeal. So it means that the chances for both parties to appeal was very limited. And next, the decisions or awards from the arbitral proceeding is binding, so parties need to obey the decision. So it means that the award that made by the arbitrator, both of the parties need to obey and need to accept the awards that made by the arbitrator. And next, meaning that through arbitration, it provides finality decision but limits the rights to appeal. . we move on to the next explanation. Additionally, to appeal or setting aside the arbitration decision, it is very limited. No matter how many times you want or ask to appeal, it may not be available at all. It means that, as we know, that the opportunities for the parties to appeal the decision, no matter how many times you ask or you want to appeal it, it may not be available at all, or it may not be working at all. And last, the disputing parties must adhere to the arbitrator's decision and usually can appeal the decision to court. This means that the arbitrator decision, which is what, cannot be appealed to a court. So it's only reliable or available in the arbitration proceedings or in the dispute resolution. And that's all from my point. So we will move on to the conclusion. The first point of conclusion is arbitration might be a better option in situations where the parties want a final binding decision. It means that arbitration could be the best solution or the best way of dispute resolution for the parties that want a final or binding decision. And next, arbitration can help the parties to avoid random selection judges with little expertise in the area of their dispute. So we all know that the arbitration proceedings we need to choose the best judges that fits in the dispute resolution, that experts in certain matters, so that the arbitrator can give award or make a decision that suitable for the dispute resolution for the dispute. And lastly, parties can choose retired judges with specialized experience as arbitrators to help resolve their dispute. So that's all. So that's the conclusion, and I would like to close the presentation for our group. So that's all from our groups. Thank you for listening, and we hope you understand and can make can get a better understanding about arbitration proceeding advantages. So that's all from us. Thank you.